Stop scrolling, because 2026 immigration is moving in two directions at once. Some green card categories appear to be making real progress, while stricter verification steps, longer processing pressure, and tougher enforcement trends are also being reported. If you're waiting on a case, planning international travel, or thinking about programs like the Diversity Visa Lottery, the biggest risk right now is acting on incomplete headlines instead of checking what's actually confirmed through official sources. Quick note before we begin. This is general information, not legal advice. Immigration rules and processing patterns can change, and some items discussed online are proposals or early reporting rather than finalized policy. When something matters to your life, your travel plans, your filing strategy, your eligibility, verify it through official government publications, official portals, and reputable primary source reporting. With that said, here's the big picture. The 2026 immigration environment is sending mixed signals. There are signs of forward movement in certain green card categories that families and workers track closely. At the same time, there are multiple indicators of tightening. More documentation requirements in specific programs, more compliance-focused travel measures, and enforcement-related stories that keep people anxious even when they feel they are doing things legally. For many applicants, the question is no longer just what are the rules? It's also, how are these rules being implemented in practice and what could change next? Let's start with the update that affects a huge number of applicants every month. The Visa Bulletin. Recent coverage around the April Bulletin has described encouraging movement in several family-based green card categories. That matters because family categories are often where long waits are felt most intensely. Spouses separated across borders, children aging out, parents waiting for processing, and relatives trying to plan their lives around a priority date. When family categories move forward, it can translate into real progress. More people become eligible to file, to adjust status, or to move to the final steps of consular processing. For many families, even a small movement feels like breathing room. On the employment side, the overall picture is often described as mixed. Some categories move, some stall, and some shift unpredictably depending on demand and annual limits. One highlight that has been mentioned repeatedly is EB3 being current for many countries. If that matches your country and category in the official bulletin, it can be a major development because it removes a timing barrier for a large number of applicants. But here's the part many people misunderstand. Current does not mean approved immediately. It means the priority date gate is open. You still have to deal with the real-world process. Filing accuracy, background checks, medical exams, interview scheduling, and the capacity of whichever office is handling your case. A current category can still move slowly if the system is overloaded or if your file needs additional review. So the practical advice here is simple and boring, but it saves people months. If movement in the bulletin helps you, don't wait until the last moment and don't rush. Rushed filings create problems. Wrong dates, inconsistent address history, missing documents, outdated forms, incomplete translations, or mistakes in family information. Those mistakes commonly lead to requests for evidence, delays, or even denials in serious situations. If your category is opening up, treat it like a window and use it to prepare carefully. Now, shifting from processing movement to policy changes, there has been reporting about a major fee adjustment related to citizenship renunciation. Some coverage has described the cost dropping significantly from a much higher fee to a much lower one. If you've seen those numbers circulating, treat them carefully. Fees are only real when officially published by the appropriate authority, and renunciation is not a casual decision. It is permanent. It can affect your long-term mobility, family planning, and tax considerations depending on your circumstances. Even if the fee is lower, the consequences are not smaller. So the practical message is, if this topic applies to you, verify the official fee schedule and official procedures first, then speak with qualified professionals if you have tax or complex legal implications. Headlines make it sound like a simple form. It is not. Next is visitor visa policy and compliance, where reporting has described an expanded bond program for certain travelers. The way it has been described in some sources is that a bond, sometimes cited in the five-figure range, may be required in certain cases to discourage overstays, and that more countries may have been included. Whether you agree with that approach or not, the policy logic is clear. It treats overstay prevention as a higher priority and uses financial leverage to enforce compliance. It also signals that visitor policy can tighten quickly and that even routine travel can become more complex when the government shifts toward stricter screening and enforcement tools. If you travel on visitor status, the practical takeaway is not panic, it's compliance. Have a clear purpose for travel. Have a realistic itinerary. Be prepared to show ties to home, work, school, family responsibilities, financial stability, and a history of compliance. Do not work without authorization. Do not overstay. Small mistakes can create big future consequences, especially when enforcement trends are tight. On the legislative front, there has also been coverage of a bipartisan proposal connected to the H-1B ecosystem, specifically aimed at healthcare staffing. The story, as reported, is that lawmakers introduced a bill to waive a controversial high fee linked to certain H-1B-related processes for healthcare workers. The reason presented is staffing shortage relief. If you're a healthcare employer or a healthcare worker, it's worth tracking, but it's equally important to stay realistic. A bill is not a law. Bills can be amended, stalled, rewritten, or dropped. Still, it shows that targeted sector-based immigration policy continues to be an active space, especially in industries where shortages are highly visible. There was also a lighter headline in the mix: immigrants and immigrant communities being recognized in major entertainment coverage, with multiple wins at a large awards event. That doesn't change immigration rules, but it matters culturally. In a time when immigration conversations can be dominated by enforcement and restriction, it's a reminder that immigrants are part of every major sector: medicine, technology, business, education, and culture. The policy debate is often harsh. The lived reality is that immigrant communities are deeply woven into daily life. Now let's talk about timelines, because even when categories move, families still experience the system through waiting. K-1 fiancé visa processing continues to be commonly described as lengthy, with many estimates landing somewhere around the better part of a year for many cases, depending on workload, case complexity, and the embassy's capacity. It's not just the petition, it's the full chain: petition processing, document preparation, interview scheduling, and final issuance. If you're in a fiancé or spousal process, the most useful mindset is to treat it like a long project. Keep every record, save every notice, maintain consistent contact information, respond on time, and avoid building major life plans on optimistic guesses, because delays are common even when nothing is wrong. A travel update that many viewers find practically useful involves Argentina. Reporting has described that Argentina updated entry rules to allow visa-free entry for travelers who hold a valid U.S. green card or certain U.S. visas. Categories commonly listed in coverage include professional work visas and standard visitor visas, along with a few specialty categories. If this is relevant to you, the most important advice is verification. Entry rules can depend on your passport nationality, the validity of your U.S. document, the exact visa classification, and the length of stay allowed. Visa-free does not mean unrestricted. Airlines can also enforce documentation rules strictly, so confirm the current requirements through official Argentine government sources before traveling, and carry clear proof of your status. Now, one of the most important 2026 updates being discussed involves the Diversity Visa Program, also known as the Green Card Lottery. Public coverage has described stricter entry rules aimed at reducing fraud and strengthening identity verification. The major operational change being discussed is a passport requirement at the entry stage, including uploading a scan of the passport's biographic page. Some reports tie this to an effective date in April 2026. If that becomes the final rule, it changes how people must prepare. In the past, some applicants waited until the DV window opened and then scrambled. A passport upload requirement means you may need a valid passport ready at the moment you submit. That could reduce duplicate or fake entries, but it can also disadvantage people in countries where passport issuance is slow or where access is difficult. Because DV programs attract scams every year, this also creates a new scam angle. If people are told you must upload your passport, scammers will use that to trick applicants into sending passport scans to unofficial sites or agents. The safest habits are consistent. Only use official DV registration channels. Never trust anyone who promises guaranteed selection. Never pay large processing fees for entry. And never share sensitive documents with strangers. Now we need to address the enforcement side, because this is the part that creates the most anxiety. News coverage sometimes highlights cases where a person with an ongoing or pending immigration process is detained for extended periods. The original script referenced a case involving detention lasting many months, even though a green card-related process was pending. Cases like this raise concerns about due process, the length of detention, and the uncertainty families face while cases remain unresolved. At the same time, it's also true that headlines often omit key facts, prior orders, identity issues, criminal allegations, or other details that can materially change what enforcement can do. So, the responsible takeaway is twofold. First, detention can happen even when a person believes they are in process, especially if there are prior issues. Second, if enforcement action happens, the correct response is immediate qualified legal help, not social media advice. Finally, there are broader, quiet changes being discussed that can reshape immigrant life in ways that don't always make headlines. Some reports describe stricter border screening and re-entry scrutiny, tougher re-evaluations for certain groups before permanent residence is granted, and possible changes that could affect access to certain financial services for permanent residents, such as business lending. These are the kinds of shifts that don't feel dramatic until they hit you personally. When you travel, when you apply for financing, when you renew documents, or when a routine process becomes a longer review. Combined with higher fees in some areas and a stricter enforcement posture, the overall direction many observers describe is a system that becomes more documentation-heavy and less forgiving of mistakes. So, what should you do with all of this right now in a way that actually helps you? First, separate confirmed information from reported or proposed information. Visa Bulletin movement is confirmable through official monthly publications. Proposed bills are not law until passed and implemented. Future DV changes should be confirmed through official instructions when the program opens. Treat reports say as a starting point, not a final answer. Second, get your documentation organized early. Many delays happen because of missing records, inconsistent information, or avoidable errors. Keep your passport valid. Keep copies of filings. Keep receipt notices. Save confirmation numbers. Store identity documents securely. This is especially important as systems become more verification-based. Third, be cautious with travel if you have a complicated history. If you have past overstays, removal orders, unresolved status issues, or a sensitive pending case, get professional advice before travel, particularly international travel. Travel can be routine for many people, but for some, it creates a risk window. Fourth, protect yourself against scams. Immigration scams spike whenever there is movement. Visa Bulletin progress, DV updates, fee changes, or fast processing rumors. Nobody can guarantee results. No legitimate government process requires gift cards, crypto, or pressure tactics. If someone insists you must act today or pay immediately, treat it as suspicious. Fifth, manage expectations. Some parts of the system are improving for some categories, others are tightening. Both can be true. The people who do best in that environment are the people who stay organized, verify claims, avoid rushed mistakes, and get real help when their case is high risk. If you take one message from this 2026 update, let it be this: opportunities and risks are rising together. Movement in the bulletin can help you, but stricter verification can slow you if you're unprepared. Travel policies can be convenient, but enforcement can be unpredictable if your history is complicated. And major program changes like DV verification, if implemented, reward preparation and punish last-minute scrambling. That's the update. If you found it helpful, like and subscribe so you don't miss the next one. And if you want, share in the comments what you're dealing with right now. Family petition, employment process, DV lottery plans, travel concerns, or processing delays, so the next update can focus on what viewers actually need. Take care, and I'll see you in the next video.